situation at the moment.
Okay, thank you. Thank you very much.
Simon Fell.
Thank you, Chair. I'd just like to ask a couple of questions around both language and process, if you don't mind. So the government's criticised lawyers in the past and put statements out on Twitter talking about activist lawyers making complaints about last-minute applications for halting deportation. I'm interested in your views as to why these last-minute applications are being made and whether you think criticism like that is justified. And to try and keep my question short, I'll throw another one in now. Do you think that term of activist lawyers is fair, and is it helpful or not to you? I'll throw that open for any of you to answer.
Well, I would say that the way the term is being used, it's obviously being used in a certain way that appears to be some sort of propaganda campaign. And certainly I would say it's dangerous and depressing. And we've seen that the profession and legal regulatory bodies have pushed back very, very strongly against the use of that term in the way it has been deployed by the Prime Minister and the Home Secretary. I think it's really important to remember that us lawyers can only advise on the law as Parliament makes it. So we don't get to bring a case and make up the law when we get to court. We obviously have to argue on the basis of the law. And to give an example, just last week, there was a case that was reported. I haven't actually seen the case report, but I saw the article about it in the newspapers, where a judge ruled, where in a challenge to removals based on from people who had come over in small boats. A judge ruled that it was strongly arguable that the Home Secretary had not been applying her own policy for identifying victims of trafficking. So there were questions in the screening process that had been missed in these cases, which were designed to identify victims of trafficking. And on that basis, a halt was placed, as I understand it, on the removal. And that wasn't a case, that's not an activist lawyer. They're simply asking for the policy that is in place to be applied. So I would very strongly suggest that is really unhelpful. In terms of delays in bringing cases, it may be that David can say more about this, but my understanding is that for these cases, at least, I think the process, as I understand, has changed a bit more recently, but certainly over the summer, as I understand it, there was a process going on where people were not being told. They would arrive on small boats, but they weren't told that they were in the Dublin process until very late in the day. So they would have a screening interview, and because they had come on the small boat, a request would be made under Dublin to another member state. That person is supposed to be given information about the Dublin process, but apparently that was not routinely happening. Certainly from the solicitors that I've spoke to that regularly are doing this sort of work. And it meant that people were then released into the community, and one day they would go to report, and at that point they would be told that their asylum claim was certified and they were going to be sent to another country, and often served with removal directions around the same time. So they had very short notice of the fact that they were in this process and that this was going to happen. So in that case, and then at that point they're detained. So if you are detained and you have either maybe 5 days, maybe 2 weeks before your date of removal, and in that time you have to get a lawyer. Often that lawyer has to apply. The lawyer has to take instructions, has to make legal aid applications, has to you have to write a pre-action letter so that the government has the opportunity to decide whether to defend a case or agree with your arguments about why the decision is unlawful. and then they go to court. So it's not a process that is, it's a difficult process. And if people are not told in enough time, then challenges will necessarily be at the last minute. And obviously it's our job to advise our clients properly on the law and on their legal rights. And we have to do that. And there are procedures put in place for urgent applications where that's necessary. I do understand, sorry, that I should just say that more recently I understand that there have been improvements in the time given for people, the service of decisions. So there is slightly less time pressure, which obviously can then mean that hopefully the applications are less last minute.
Thank you. David Blundell.
Thank you. I can't comment on the precise issue which Ms. Noor just referred to about lack of information as some. I simply don't have any information on that. I haven't been instructed in any cases around that issue. What I'd say generally on this, and again, I'm absolutely restricting this to a legal comment on how the law deals with this, but although I can see how the issue has become focused, if there have been recent last-minute challenges, the law has always, in the context of asylum and immigration, made very powerful and strict provision for the accommodation of last-minute late challenges, because they are seen as an important way for asylum seekers and immigrants to vindicate potential rights which they have. There's a process under the immigration rules, for example, to do with what are called fresh claims, paragraph 353 of the rules, which has caused an enormous amount of litigation over the years. But going back to the early 90s, you have statements of high principle from Sir Thomas Bingham, as he then was when he was Master of the Rolls, explaining that it was incredibly important in any fair immigration and asylum system that there had to be a mechanism for dealing with, for example, changes in the case that people put forward for perfectly valid reasons. It may be the country situations change, it may be that people's position changes. And it's always been seen as being important to have those kind of last-minute challenges accommodated. So of course, there may be individual cases where particular requirements haven't been complied with. And again, the High Court and Divisional Court and the Court of Appeal have in recent years given quite strong guidance about duties of candour on, for example, claimant lawyers as to what the position is with their clients. And in my experience, those are generally very, very strongly complied with. And lawyers take those kind of obligations extremely seriously. And actually, the instances of abuse are, again, in my experience, extremely rare. It's not to say they don't happen. They happen in any field of law, but they are very rare. It's just that obviously this is an area which is highly politicised, and so it tends to draw attention more because of that.
Thank you. Can I just ask, on that politicisation point, and I don't want to draw you too much on it, but does that make it more difficult for you to represent your clients? And does that introduce an unnecessary challenge in using language like that, using scapegoating language like that, in terms of your ability to do your job and represent them well?
So, in terms of, most of the cases I do are for the government, not exclusively. I act against the government as well. I have a mixed practice, but I've done more cases certainly for the government over the years than I have against it. I think that's quite a difficult question to answer. I mean, I think as a lawyer, you come at a case completely neutrally, and we have very strict professional obligations on what we can and can't do. Ms. Noor referred to that just a moment ago. We can only plead a case that we have proper evidence and information to substantiate, and that applies both ways. It applies to the government just as much as it applies to claimants as well. And I think when you're acting as a lawyer, even in a highly politicised field like that, that's what conditions your approach to a case. You have to be able to shut out the outside noise and get on and just make the arguments that you're legally there to make. So you do that to the very best of your ability. I think beyond that, I find that quite a difficult question to answer.
Thank you. Diane Abbott.